The latest weather, traffic, and news updates online at 560theanswer.com. Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Proft on AM 560. The Answer.
Top of the morning, Dan Proft here. Here's again what the good governor, J.B. Pritzker, had to say. February of 2022, when he signed the so-called Safety Act into law. Opponents, this is to you, 100 of the state's 102 county state's attorneys at the time, and people like me, other commonsensical people. This is what he had to say to us.
Opponents of this law don't want any change, don't believe there is injustice in the system, and are preying upon fear of change to lie and fearmonger in defense of the status quo.
Opponents were liars and fearmongers. You heard it right there. And this promise.
All Illinoisans will live in a safer and more just state with this law on the books.
Is that what happened? A man with a pending juvenile gun case has become the 25th person accused of shooting, killing, or trying to shoot or kill someone in Chicago this year while on felony pretrial release. The crimes involved 40 victims, 8 of whom dead. That was beginning of November. Or that was, and of course, this is the long-running series that CWB Chicago has been reporting on for the last 3 years, actually going back the last 5 years, because in Cook County under former Chief Judge Tim Evans, this was already the order of the day before Pritzker scaled it and made it statewide. And the stories week after week. Man accused of shooting a concealed carry holder on the Red Line this summer was supposed to be confined to his home under one of the judge's, Cook County Chief Judge's, electronic monitoring programs, but he was instead on the street, one of many violations he racked up in the weeks before the attack. The pedestrian story is that come and go very quickly until you have something that really captures people's attention, like when that poor young woman, Bethany McGee, was lit on fire by somebody who had been arrested 72 times, was on electronic monitoring, was violating the terms of his electronic monitoring. The staff of the Chief Judge's office reportedly was telling the Chief Judge, we have a problem with this habitual violent offender, and nothing was done. And then he's standing over a poor young woman after having lit her on fire saying, burn, bitch, burn. So, Pritzker had it right. Illinois is a safer place thanks to no cash bail and the default in all but the most violent crimes to pretrial release. For more on this, we're pleased to be joined by one of the leading antagonists of the governor as it pertains to this law. I mean, really, without Jim Glasgow's leadership, it would not have gotten the attention and would not have resulted in, after Pritzker's re-election victory, some changes being made. Not nearly enough, because in my view, the whole thing should be repealed. But it was Jim Glasgow who exhibited, really most of the political courage from that from that cohort of county state's attorneys. There were others, but Glasgow was really the leader, and he deserves credit for it because I think we all know what has transpired over the last 3 years. The evidence is fairly overwhelming. Jim Glasgow, Will County State's Attorney, thanks for joining us again. Appreciate it.
Good morning, Dan. How are you?
Good. We haven't talked in a while, so, to take stock here, we've seen some commentary from people like former Riverside Police Chief Tom Weitzel on some of the changes that could be made and should be made if you can't get this thing repealed altogether. A lot of what Weitzel was focused on was this sort of standard of flight risk for the purposes of pretrial detention. But what's your perspective after now having worked under this law for the last couple of years?
Well, I just like to go back to your opening statement where we were so castigated for challenging this law, because what people don't realize is that because we sued and because we won a decision in Kankakee, it forced them to the bargaining table, and we got a 300-page amendment that saved us from Armageddon, because the original law said no matter what crime you committed, you were out in 90 days. And when you didn't show up to court, they took away the judge's authority to issue a warrant. So a guy that killed 50 people could have stood across the courthouse and given us the finger, and the police wouldn't have had any ability to arrest him again. That's how insane the original law was. The other thing was when you tried to detain someone, you had to prove they were a danger to a specific identifiable person and not the public as a whole, which means if I murdered my wife, I come before the judge and say, hey, judge, got to let me go. The only person I'm a threat to, I killed. That's how insane the original bill was. And the media, of course, never, ever covers that. And it's just a complete gloss over. And we literally saved the state from Armageddon by filing that lawsuit and getting them to the bargaining table.
Well, you have to provide evidence of a specific person being threatened. Imagine if, you don't have to imagine it. I mean, that would be like, we can't detain the guy who nearly burned Bethany McGee to death because he just attacks people randomly, as many of these criminals clearly with mental health issues do. Because he attacks people randomly, that's the basis to release to provide pretrial release for somebody like that. That was the theory, at least.
Yes, and we, as I said, we got substantial amendments to those issues I just described, or we wouldn't have survived. But we still have ridiculous things on the books, like if you possess less than 5 grams of fentanyl, which is enough to kill 2,500 people, I cannot detain you, even if you have a murder conviction, an armed robbery conviction. And that's the essence of what needs to be fixed still in the bill, is to give the judges the authority back to look at the fact that this guy has lived a 30-year life of crime before he committed this new crime. And to protect the public, he needs to be detained. They don't have that authority right now.
Because the judges are tasked to be willfully blind to a criminal's history.
Yes.
Yeah.
But the ones, we got to get rid of these mandatory no detention. That's ridiculous, because it doesn't take into account. My investigator in my office looked out his kitchen window and saw a guy sitting in his car in his garage. He goes out and arrests him for burglary. The man had been arrested 37 times prior to that and had multiple burglary convictions. We take him before the judge, and he was immediately released. My investigator was going home that night and drove by an alley where the guy was sitting and getting drunk and waved to my investigator laughing. I think that kind of encapsulates what I'm talking about. Somebody arrested 37 times with multiple convictions, multiple prison stays on a Class 2 burglary of a garage right next to a home. It's a very dangerous situation. He's out the next day.
Right. And I mean, is your view that this should be repealed altogether? Or is, and I mean, I guess just philosophically, whether that's politically feasible is a different story. But I mean, is that your position?
Yeah, but it's, like you said, Dan, it's not politically feasible, and so we got to try to work within the confines that we have. You remember the bill that was put out not too long ago? It got a bill number and it got a first reading, and it said as follows: the police will not be able to stop a car that has no license plate. Police can't stop a car until the car is 26 miles over the speed limit. Can't stop a car with blacked out windows. And if they do, any evidence obtained is suppressed automatically, even if the defendant confesses and offers the search to the officers. you know that license plates with our block cameras, those are the essence of our crime-solving abilities. Yet this bill got printed and read, and it was only, thank God, law enforcement was awake, and they rose up, and it was pulled. And you did hear about that, Bill, didn't you?
Yes. Yeah. Right. Yeah. That was sponsored by one of the authors of the Safety Act.
Oh yes, one of the prime authors, but it gave us a window into their soul. I mean, that's basically the end of days. If that law went into effect, the inmates would run the asylum.
And so, I mean, just so we have that, if we can't repeal it altogether, the punch list, no mandatory releases. Contextual, so you don't require judges to be willfully blind. Is there still a problem, as Weitzel says, in your view, with the standard for flight risk?
I don't know that that's one of the major problems. But obviously, these people out on ankle monitors, there's a lot of flexibility and leeway to commit crimes that we won't know about. So, and it's hard to document if they're not caught committing the crime. You follow me? I mean, so
yes.
The ability, I talked about the New Jersey system when we were initially challenging this, and they give their judges a lot of authority to analyze everything, and then they have holding periods to give the prosecutor plenty of time competently prosecute the case and win the case to protect the law-abiding citizens of their community. And that's all we're asking to be able to do, and use common sense. But the person's prior criminal history has to be one of the most critical factors in determining whether you detain them. And right now, that's not the case.
And are you encouraged by both the new chief judge, Chuck Beach, and the new Cook County State's Attorney, both sort of saying in different ways that electronic monitoring is not a proxy for pretrial detention, and Beach, saying I'm going to stand up a committee to urgently review the electronic monitoring program as it has been administered. I mean, I guess my question is, too, with that, I mean, it's nice to say those things, but if you don't deal with the underlying law, then is there a way to make electronic monitoring that much more efficient, effective, accountable, so that it serves as a closer approximation to pretrial detention, or are we just whistling past the graveyard on that?
Yeah, that I don't know the answer to that question. Obviously, with the dangerous offenders, physical incarceration is the true answer. And you mentioned Eileen O'Neill Burke. I'd like to throw some kudos out to her. Wow. You talk about a 180-degree change at the Cook County State's Attorney's Office. We got it. And thank God. I wish she had been state's attorney when we were battling this original Safety Act. But she has, she and I think very similarly about public safety and the importance of protecting crime victims. And thank God she won the election.
So is this still a hot topic among state's attorneys that you speak with around the state? I mean, is this something where once we get into the height of the new legislative session after the first of the year and the campaign as well, that there are going to be people that prosecute this case in terms of public policy like you're describing?
Yes, and just so you know, I mean, one of the things that spurred the ease with which this Safety Act got passed is Kim Fox. She was complicit. She helped write it.
Oh, yeah.
And I only had one phone conversation with her. That's the only time I ever spoke to her the whole time she was in there. And she lied to me. So that was a great christening. And, I wanted to have my prosecutors sit with her experienced prosecutors and talk about problems with the Safety Act so we could propose amendments. And she said she would do that. And then when it came time to do that, I showed up with my prosecutors, and she sent her PIO.
Mm-hmm.
So she crashed and burned, but she never was intending to do anything about it.
Well, there were two.
And people have to understand, Eileen O'Neill Burke is down about 400 prosecutors. So the people of Cook County, you need to rise up and make sure she gets the assistant state's attorney she needs. That's one of the luxuries I have down here in Will County. I have the appropriate number of attorneys in the courtroom, and we win our cases. We have time to prepare them and make sure that justice is done. And the fact that she is doing the job she is doing, I think she only has like 540 prosecutors. They used to have 900. And I mean, that's
cops are down, prosecutors are down, right? Mm-hmm.
Oh, horribly under Fox. Yeah.
Well, and also, too, I mean, I don't want to leave him out. Credit where credit's due. Lake County State's Attorney, because this is an important Collier County, of course, a big one. Lake County State's Attorney Eric Reinhardt was the other county state's attorney. There were 2 out of 102, Kim Fox and him. That was impactful, too. It gave some suburban cover to Pritzker on this.
Right. Well, he was a habitual liar. He continually repeated the statement that, all serious violent offenders will remain in custody until their trial. That's what he would say, which was absolutely not the truth. So, he was a problem, but we had 100 state's attorneys against those 2. And unfortunately, because Cook County is so large, that one prosecutor was, a daunting opponent.
Is there anything else that's coming down the pike that concerns you in General Assembly in terms of public safety that we should be apprised of?
Well, certainly this immigration issue. My God. Look, my mother was born in Ireland. I'm the son of an immigrant. She came here. She had a job. She had a place to live and never got any government aid. That's the way immigration was originally designed in this country. And look, we see what it's turned into. And, with anywhere between 12 and 15 million people coming in the last 4 years with literally no vetting. Obviously Chicago received a number of these individuals. Look, if you're in the country illegally, that's unlawful. So you don't have a lawful right to be here. And they keep talking about it being a civil issue. It is not a civil issue. Under the federal statute, it is a misdemeanor, and it is punishable by up to 6 months in jail. And so, that's an issue that obviously we're struggling with. And like I said, I am not against the immigration, being the son of an immigrant. But at the same time, we have to use common sense and good judgment, which for 4 years we clearly did not.
Yeah. Just going back to that Bethany McGee case, there's a lot of heat, including from me, directed at the judges in Lawrence Reed's career as a habitual offender, including most recently to the Judge Melina Gonzalez. In that instance, I mean, just so we're clear, because we're talking about how limited judicial discretion is in some cases, but in other circumstances. Is it your view that Melina Gonzalez, the last person, she put him out on electronic monitoring after he beat up a nurse at the psych ward in McNeil and Berwyn, and then another judge after that modified his electronic monitoring order to make it more permissive. Are those judges to be held accountable as well, that they used their discretion improperly, or did they not have the discretion that we believe they had?
Well, again, holding them accountable is a whole other story. Certainly in violent crimes like you're describing there, I think there should be certainly a more tendency towards incarceration.
And the judges could have done that if they wanted to.
Yes.
Yeah.
That's the sad part. When they had the discretion to do it and they didn't do it, that's the outlier part. That that's the quality of our judges. And so.
Right.
But again, our whole society is a mess. I mean, these attacks on the subway, where are the people coming to her rescue?
Right.
I mean, I was born in 1950, and my dad did 4 years in World War II, and he taught me never walk away from a situation like that. You have to do something. that credo apparently is kind of on the wane in our society. And remember the poor gentleman that put the guy in the headlock in New York?
Daniel Penny, right?
Yeah. I mean, the fact that he got prosecuted was an outrage. But you want to deter law-abiding citizens from helping. That's a good way to do it. So we've got problems in our legal system at all levels. We just have to keep our eyes open and try to advocate for common sense and justice and keep going.
Jim Glasgow, Will County State's Attorney. Jim, thanks for joining us again. Appreciate it.
Dan, thanks. Take care. Bye-bye.
And Jim, thank you. And Jim joined us on the Turnkey.Pro answer line.
This is Chicago's Morning Answer
Hallelujah! Holy
on AM 560.
Where's the Tylenol?
The Answer.
I love giving